Hey guys, this is Mike from Invention City. Today I want to talk to you about copyright. Copyright is a form of intellectual property that is probably underutilized by inventors. It covers artistic expression, and you have copyright automatically upon creation, which is really cool because that means you've got copyright for free when you create the work of art. What is defined as a work of art? A photograph, a video, a sales sheet, instruction sheets, things where you're using your own language, where your expression is unique and special and can be identified as yours. Those are all things that can be covered by copyright. I've come to copyright very specifically because we have an inventor who has a new kind of doll, and we had to discuss with her, how do you protect this? And so obviously trademark, protecting the name of the doll, was one level of protection. And then we looked into the possibility of using design patents. And design patents are okay. They can cover the look of something, but they're more generally used for hard products, for things that are done in mass production, where the lines are very, very clear. Okay, they're very clear, hard lines that can be identified as unique. And so, for example, the bevel of an iPhone is something you might want to protect with a design patent, but it's not really a copyright. It's not so much artistic expression, although, this is something that might be considered. Here's the thing. With a doll has a unique look, a unique feel, not just the expression on the face of the doll, but also the clothes that the doll wears, the shape of the doll, all these things that are kind of touchy-feely. Those kinds of things, if you can show them in photographs and written description, are all subject to copyright. And so that's something to look at. And copyright is not expensive. You can file on your own for $65. And the great thing about filing for a copyright is that once you do, it's very, very official. It's easier to enforce a copyright that has been filed with the Copyright Office than one that has not. You don't need to file. You have copyright automatically upon creation. But if you do file, then enforcing your copyright becomes much easier. A great example for use of copyright is Thai Inc. in their defense of their Beanie Babies plush toys. You remember Beanie Babies? They were cute little toys that were everywhere. Millions and millions and millions, maybe even billions of these things are out there. And Thai Inc. was very aggressive in defending their intellectual property rights. Thai had both design patents and copyrights on all of the designs of their Beanie Babies toys. But when they went to court, they almost exclusively used copyright to protect their designs. That's what they went to court, and that's how they fought against the knockoffs. And so if it worked for them, I'm thinking it's probably pretty good for anyone else who wants to protect something like a doll or a plush toy. And I'm also very interested in the possibility of using it for more standard inventions if they have arguably some kind of artistic expression to them. And here's an example. These are the Midnight Eyes. You may have seen them. They're Halloween decorations. And given this is around Halloween, this is probably a pretty good thing to show. So these were patent protected. I think the patents have expired. We're no longer making any money on it. But I think going back and looking back at this, we might have actually been able to file for copyright because, again, these are unique looks on the look of the eyes, on the sets of the eyes. That's kind of a unique look. And so we probably should have had copyright protection. And then we'd still be able to collect royalties on it, which would be really cool. But we don't. And so, and statute of limitations has run out. So it's no longer an issue. But this is exactly the kind of thing I mean. So if you have something like that, definitely consider copyright protection. Okay, see you again soon.